Well, hello, Julie, and hello, Jeff. Nice to see you today. My name's Tracy Jackson. I'm the mediator that you've chosen to help you facilitate, to help you reach agreement regarding your family law property matter. I'm a qualified lawyer and I'm also a nationally accredited mediator. So I've conducted many mediations of this kind in the past, and I'm fairly confident today that with a bit of hard work, we can arrive at a resolution today in your matter as well. Okay, I'd like to thank you for coming today, first of all. Look, are you guys comfortable? Are you both comfortable where you are? And does anybody want a drink of water? We've got water in the middle of the table. Help yourself.
Thank you.
Okay. All right. So thank you for coming today. I know it mightn't be easy to confront each other in these circumstances. I know that emotions can run high. Look, if it's any consolation, I can guarantee you that you're both feeling pretty much the same. So it's not really a comfortable sort of situation for anybody. But look, that's perfectly normal. And I just think that you're to be congratulated for making the commitment to come here. You've made the first step. And try to negotiate in good faith so that we can make a really genuine effort to resolve this dispute. One good thing I noticed, guys, is that I saw that the orders for mediation were made by consent. And I also see that you've got a parenting plan in place. And so what that tells me is that you're both perfectly capable of reaching agreement about the big issues, about the things that count. So I'm pretty confident that you've both got the skills and the commitment that you need to work today to resolve the property matter as well. Do you think so?
Yes.
Yeah. Look, we'll be here today for about 4 hours. Now, sometimes these things can run a little bit over time. So if you've got any time constraints, can you just let me know now and we can try and sort something out? I'll let you know about the facilities. We've got separate rooms available here, so if at any point in time that you need some time out or if you need some privacy to make a phone call, by all means let me know and we can put you into one of the separate rooms. There will come a time, probably a little later in the mediation, when I might want to consult with you separately in these rooms as well. So don't be afraid to ask if you need to break out into those rooms. We've got toilets down the end of the hallway here, and on the way past there you'll see the coffee and tea. Don't be afraid, go and help yourself and bring some back into the room. Nobody's judging you today. You can have 2 or 4 cups. No limit on coffee today. It's going to be stressful. Be kind to yourselves. I want to talk first a bit about mediation and why we're here today. Why we're here at mediation instead of just rushing straight off to court. I think mediation's a great way where we can generate some options for both of you. Options so that you might resolve this dispute without the need for litigation, without the need to go to court. So this means a couple of things. I mean, obviously it means that you save financially, and that's a really big point. I'm sure that it is for both of you. It can be an incredible financial strain going to court. But I guess one of the things you may not have given a whole lot of thought to is the emotional drain, the emotional cost on you. You see, at the moment, you two guys are entrenched in warfare. You're entrenched in the most horrid war. Your affidavits and your emails that you fire off, they're bullets and missiles. You've got your army of witnesses fighting for you and you're living, sleeping, eating and breathing this dispute every day of your life. Your lives are on hold and you can't move forward, so you can't find that closure. So you can't underestimate the harm or the stress that emotional drain is putting on you both. And it would be great if you could be free of this whole dispute and if you could move on. And I think, think for a minute about what it would be like to just walk out of here today and breathe that big sigh and know that it's over. Know that you don't have to worry about any more court dates. You don't have to worry about any more missiles, any bullets, any emails. You don't have to cringe whenever your email comes through on your phone or your computer. So let's see if we can get that done today, because, see, here in mediation, you guys are ordinary people. You're ordinary people and you're empowered to make decisions about your own lives and about your matter. But in court, you're puppets and players. The decision's taken out of your hands and the outcome's imposed upon you, whether you like it or not. So we want to arrive at a resolution today that you guys can live with. And I picked that language deliberately. I'm deliberately saying live with. I'm not saying that you're going to be walking out of here, punch in the air, that you're going to be happy, that you're going to be ecstatic about the outcome. I'm not going to say that it's an ideal outcome for you. The very nature of the dispute that you're involved in is that it's going to need some compromise. You're going to have to both shift from your positions that you're in. And when that happens, we're going to arrive at a decision or an outcome that you can live with. One that you can live with, but one that can give you back your life. So I think it's really important that you keep that in mind and keep that in the back of your mind whenever you're looking at a proposal from the other side today. Whenever somebody's putting forward an offer, I want you to sit and weigh that up, but also take into consideration how much it is worth for you today to walk out of here with this finalised and resolved. So keep the big picture in mind. I'm going to ask you to do some tough things today. I'm going to ask you to, to really keep your emotions in check. I'm going to ask you to treat this more like a commercial transaction than an emotional one. I'm going to ask you to really make some compromises, to start thinking realistically about the things that you can definitely not live without and the things that you can live with. Okay, so there's some important aspects of mediation that I think we all need to know about and that I'd like to tell you about. I know you both signed confidentiality agreements, but I just want to be clear about this one. Confidentiality is the most important aspect of mediation. It comes in two separate layers. Firstly, I'll maintain confidentiality amongst you guys, amongst you two. So, Julie, I won't tell you anything that Jeff tells me. And Jeff, I won't tell you anything that Julie tells me. So, when I'm talking to you separately, I will listen. I will talk to you about what your issues are and what your concerns are. I will help you where we can, but I won't share with the other party. So do you feel fairly confident with that? It means, yes. It means that you can be confident bouncing things off me, and it means that you can be confident saying things without feeling that they're going to come back on you. Now, the second layer of the confidentiality involves you, because the second layer is that no offer you make here today, no compromise you make, nothing can be used against you or referred to in court. You cannot discuss anything that happens here in mediation with anyone other than your lawyer. So do we agree to those rules about confidentiality? Excellent.
Yeah. Yes.
All right. The second a big component of mediation is impartiality. And I want you to be really confident with this one. This is important for me. As a mediator, I'm not taking sides. I'm not taking a view on, Jeff, whether you've got a better argument than Julie has. I'm not taking a view on whether on what the outcome should be or the resolution should be. From my point of view, the resolution should be one that you've arrived at by agreement. And it should be one that you can both live with and both walk away feeling satisfied about. So I don't want any concerns about, I don't want to feel concerned about whether I'm spending more time with one or the other, or whether I seem to be nicer to one or the other. My job here is not to make decisions or draw conclusions. My job is to help you, guide you through this process and get you to the end and hopefully get a resolution. So the way we're going to work today is that we'll have, in a short minute, I'll ask you to make an opening statement. And when I do that, I want you to bear in mind a couple of rules that we have. And they are that you need to be respectful and polite. I want you to speak in your opening statement the way you would like to hear the other person speak. I want you to take note and take care when you're speaking so that we don't let insults and offence get in the way of the facts, okay? And I'll help you with that. I'll certainly help you with that. I won't be able to provide you legal advice today, and I don't provide legal advice. But what I can do is I can assist you with the procedure here today, and I can assist you to arrive at that resolution. Now, once you've finished your opening statements, what we'll do from that is we'll establish an agenda. So this is fairly important because we need to know what we're focusing on today. We need to be directed and focused. So we're going to establish an agenda, and usually that will be about 3 or 4 points. I don't think we need to have any more than 3 or 4 issues. I've not seen a problem that can't be reduced down to a simple 3 or 4 issues. So I'll help you do that today, and we'll work towards that agenda. After the round table discussion, what we'll do then is I'll break off into separate rooms with each of you, and we'll have a talk individually about exactly where you feel, you can compromise, and I can get an idea from you about exactly what's driving you here and what concerns you have in this mediation here today. Then at the end of the day, we'll come together for a final round table conversation. And hopefully by then, what we're doing is we'll be able to reduce your agreement to writing. And once that's done, you can both sign that agreement. And that agreement can then be taken to court and made into consent orders. How does that sound for you today? Does anybody have any questions about the procedure?
No, not yet.
Okay. One final thing I want to do before we get started on your opening statements is I just want to bust a few myths. I want to go into a little bit of myth busting about some paradigms of truth that you might have at the moment. And I want to talk to you about court. Today is about, like we said before, certainty and control. Court's about high risk. Now, I can see you both looking at me thinking, nah, court's not a risk for me. I'm telling the truth. Nothing's going to get in the way. This is not a risk for me. I'll tell the truth. I've got the truth on my side. I've got my army of witnesses. We'll all go to court. And the judge can't possibly see any other side apart from mine. The judge will see. Once I bring out the truth, the judge will see that this is the decision that needs to be made. And I can see you both, and you've got to understand that you're both sitting within that paradigm. You're both thinking that I've got the truth on my side. The court will see my side of it. It's clear as a bell. There's nothing else, no other conclusion the court could reach. But I want to challenge you on that a little bit. I want to challenge you on that, and I want to tell you what that means. So, Jeff, you sit there and you firmly believe you know the truth, and as do you, Julie. And you both think that, you know, the other will be exposed in court. And that your version will come out trumps, and that you will get your nice, shiny, perfect little case and you'll take it into court and away you will go with your nice, perfect little outcome. But there's a few things that get in the way of your shiny case and your perfect outcome, because that shiny case doesn't exist. Witnesses change their stories. They leave out some facts, or they don't tell the whole truth. Or they might forget to say some things, or they change their mind about things. You might get into the witness box and under cross-examination, you might say some things that make a judge think, oh, hang on, I'm not sure that I could really trust them to be telling the truth all the time. The judge might bring their discretion into the courtroom. They might decide that a point that you think is vital is actually not relevant, and they're not going to place a lot of weight on it. And then we've got the law. You've got the law of admissibility of evidence. So much of the information you think will end up before the judge could end up being inadmissible, and most likely will. A lot of it might end up being inadmissible. It might be hearsay. It might be opinion. It might be irrelevant. So there's lots of things that can come in between, lots of things that can go wrong in between your perfect little shiny case going into court and your outcome coming out. So I want you to keep that in the back of your mind, and I want you to just think about that every time things get tough today. And I'll help you through that and help to remind you. And when we talk about why it's absolutely beneficial for you today to try your best to resolve this here today without having to go on to further litigation in court. Okay, we're going to start with some opening statements. Now, Jeff, Julie, you're the applicant in this matter. So, Julie, I'm going to ask you to do your opening statement first. And I just want you to focus on two things. I want you to tell me briefly what you want to achieve today and why.
Okay. All right.
Can
Sorry about the delay. Sorry. Yes. Well, I really just want to get this matter over and done with. It's taking up a lot of time in my life, and I do want Jeff to be able to understand that. I mean, we've both got these children, and I think that what the amount of effort that we've put into both of them and their upbringing, I think it would be. I just want Jeff to be able to understand that there should be some fairness about this, considering how much we've both done together, bringing up the kids on the farm yeah, everything we've done together.
Okay. So, Julia, I guess what I'm hearing you saying is that the most important thing for you is the children, and being able to arrive at a property settlement that will allow the children to benefit. Would that be correct?
Yes.
Okay.
Yes, I think so.
All right. Can you tell me what you want to achieve today with your property settlement? Can you tell me why you've come here and why you haven't reached a resolution beforehand? What are the reasons why you say that you should have the property settlement that you're asking for?
Because I don't think it's fair what the proposal is at the moment. So I think it's good that we talk about it and discuss what's important to both of us. And yes,
all right. Well, that's perfect. Well, I guess what I'm going to do is I'm going to put the first item on the agenda as the children's future. So we'll put that one down first. Jeff, how about you? Would you like to start out with an opening statement?
Yes. Like Julia, I would like to get this over and done with. It's always been important to me that the property would be passed on to our children and that they'd inherit enough to live a comfortable life. If the property really has to be sold, I would like a fair share, as half the money that contributed to the purchase was from my parents.
Okay. Well, Jeff, I think two things I'm picking up from there is that the first is that one of the big concerns for you in property settlement is that the children's future is provided for. Is that big, right?
Yes.
Okay.
Yes, that's correct.
Right. And I think one of the second things that you touched on there is that you're concerned that the contributions made by your parents are taken account of. Is that correct? Does that sound fair?
Yes.
Pardon me. I just have to, pardon me 1 minute. I'm sorry about that. I might need to go and get some of that coffee, I think. All right. So one of the things I think that we can certainly say we agree on is that the children are probably the most important consideration here for you both. Would that be fair to say, Julie?
Yes. Yes.
Okay. And so I think we can say that we certainly agree. Now, I think one of the things we might differ on here is that how we provide for the children in property settlement. Jeff, I'm hearing you say that it's a big concern for you that there is property to pass on to the children. And can you tell me?
Yes, that's correct.
And can you tell me why that's important to you?
Well, it's important that my children could have a future, and I'd like that future to involve agriculture if possible.
Okay.
I'm also concerned that you may not spend the funds in the most efficient way. Yeah.
Okay. So you want to make sure that the funds are secure for your children, so that they're secure and that the children can be guaranteed of having that start in life. Would you say that's fairly similar to the start in life that you had? And you're talking about your parents' contributions to your farm. Is it a similar thing? Is it a tradition for you?
Yes, in part it is.
Yeah. Okay. So it's this security and the certainty of the children's provisions that are important to you. Julie, I hear from you that that the children are important for you. What about you? Is there any reason that you would like to settle this property today?
Yes, well, I think my circumstances at the moment are a lot different to Jeff. I mean, I'm just living in some rented accommodation at the moment, and I'm just doing an admin job, and I've never really worked in admin, so that's all new to me, and I've never had to rent a house before. I've always had the luxury of living living on the land, and I think it's been a big shift for me, and I would really like to be able to come to a settlement as soon as possible. I mean, so that we both reach a conclusion that we can be both happy with and both comfortable with, and give the kids the brightest future that they can have. So yes.
All right. Well, I think that sounds perfectly reasonable, and I think what you're saying is that without property settlement, you can't provide that stable lifestyle for the children and the quality of lifestyle that you'd like to provide when they're in your care. Would that be fair to say that?
Yes, I think so. Yeah.
All right. Look, I think we've got some things that we can certainly talk about here. What I'd like to do is I'd like to break out into breakout sessions, and I'd like to narrow down the agenda with both of you so that we can focus on the issues or focus on the points of difference. I think we can say that you're in agreement about more things than you're not. Would that be fair to say that?
Yeah.
Yeah, I think you both agree that the children need to be provided for. I think at this stage, what I'm hearing from both of you is just different ways of providing for the children. I think I hear you, your concerns are with respect to what happened to the money once Julie gets it. And Julie, I think your concerns are, the delay and is stopping you from moving on with your life. I think these are things that we can probably work through, and you can probably think about things from each other's perspective for a little while. Why don't we break out into private rooms and we'll have a chat, and then we can get back in and start the round table discussion again a little bit later. How does that sound?
Sure.
Okay, lovely. Thank you. I think that's a good time, isn't it, guys? Has it been 15 minutes?
Oh, yeah, I do. Oh, God, listening to you, I think I have to rewrite mine. I took a very different approach to it.
Hang on, I'm going to stop the recording.